Every single year, the Secret Service opens tens of thousands of threat investigations against the president. Almost none of them end in charges. Not because the Secret Service is lenient, because the law makes prosecution nearly impossible. In 2003, a man posted violent rap lyrics online about killing President Bush. The Secret Service showed up at his door. He was never charged. That case would eventually travel all the way to the Supreme Court, and the ruling changed everything. By the end of this video, you'll understand exactly why the First Amendment protects more presidential threats than you ever imagined, and why that's both terrifying and completely intentional. This channel has spent months digging into constitutional law cases most people never hear about. What we found is genuinely shocking. Let's start with the law itself, because most people assume threatening the president is obviously illegal. It's not that simple. Most people don't know that the law criminalizing presidential threats is over 100 years old. It was written in 1917, during World War I. It's called 18 U.S.C. Section 871. The law makes it a federal crime to knowingly and willfully threaten the president. Sounds airtight. But those two words, knowingly and willfully, created a legal loophole big enough to drive a truck through. The problem is intent. To convict someone, prosecutors must prove the person actually meant to threaten the president. Not just that they said something violent, that they subjectively intended it as a real threat. That distinction destroyed hundreds of prosecutions. Here's the twist. Courts spent decades arguing about whose perspective should matter, the speakers or the listeners. Some circuits said, if a reasonable person would feel threatened, that's enough. Others said, you must prove what was in the defendant's mind. That disagreement meant the same words could be criminal in Georgia and perfectly legal in California. The law was a patchwork of contradictions. But here's where it gets interesting. The Supreme Court finally stepped in. And instead of fixing it, they made prosecution even harder. Most people don't know that the defining case on presidential threats wasn't about a president at all. It started with a man named Anthony Elonis and his ex-wife. After his wife left him, Elonis started posting violent rap lyrics online. One post described killing his ex-wife in graphic detail. He also posted lyrics about attacking a school and killing an FBI agent. He was arrested, convicted, sentenced to nearly 4 years. Then the Supreme Court took his case. In 2015, 8 justices sided with Elonis. His conviction was thrown out. The court said the government hadn't proven Elonis knew his posts would be seen as threats. Subjective intent matters. What nobody talks about is what this ruling meant for presidential threats specifically. It handed defendants a near-perfect defense. All a defendant needs to say is, I was venting, I was joking, I was writing fiction. I never meant it as a real threat. And proving that's a lie? Nearly impossible without a confession. But then, the court came back for round 2. In 2023, they heard a case that directly asked, what does knowingly actually mean? The case was Counterman vs. Colorado. A man sent thousands of disturbing messages to a musician. He claimed he didn't know they were threatening. The court set a new standard. The prosecution must now prove the speaker was reckless, that they consciously disregarded the risk their words would threaten someone. That sounds like progress. But here's the problem. Recklessness is still almost impossible to prove without direct evidence of the speaker's mindset. We're about to hit the midpoint twist, and it completely reframes everything we just covered about the law. Stick with me. Here's what nobody tells you. The Secret Service doesn't actually want to charge most people who threaten the president. This is the midpoint twist. Charging someone with threatening the president is often the worst thing you can do for the president's actual safety. When you charge someone, you hand them a lawyer, a trial date, and a fixed location. You can track them for 6 months. Then they walk free with a criminal record and a grudge. But when you don't charge them, you can monitor them indefinitely. You can intervene with mental health resources. You can build a relationship. The Secret Service calls this threat management. It's not just law enforcement. It's behavioral science. Research shows that most people who make threats never act on them. And most people who do act violently never made explicit threats first. That's the brutal irony. The people most dangerous to the president are almost never the ones on the threat list. I saved the most important part for right here, because this changes how we understand every single high-profile prosecution that does happen. When the government does charge someone with threatening the president, it's almost never because of the words alone. There's usually something else going on. Maybe they bought a weapon. Maybe they scouted a location. Maybe they told someone else they were serious. The threat charge is the hook. The real case is behind it. The threat statute, prosecutors admit privately, is a tool, not the goal. So who actually gets charged? Let's look at the cases that made it through and what they tell us about where the law actually draws the line. Most people don't know that the oldest charged case under Section 871 came just a year after the law passed. A man was convicted in 1919 for a verbal threat made in public. Back then, courts applied a simple test. Would a reasonable person consider this a real threat? No mental state required. That worked for 50 years. Then the internet arrived and broke everything. Online, context collapses. Sarcasm looks identical to sincerity. A joke about a politician and a genuine threat are linguistically indistinguishable. Courts have ruled consistently. The medium matters enormously. A private, direct message carries more legal weight than a public social media post. Specificity is the second factor. Saying someone should kill the president is political hyperbole. Courts have protected that language repeatedly. But I will be at the West Wing at 3 p.m. with a rifle. That specificity crosses the line. Time, place, method. The three elements that make a threat real. The third factor is pattern. One angry post is a red flag. 50 angry posts over 6 months is a prosecution. But here's where it gets interesting. Pattern evidence actually helps prosecutors get around the subjective intent problem entirely. If you posted, "I'm going to kill the president," 47 times, claiming you didn't know it would be seen as threatening becomes laughable to a jury. So the practical standard is volume, specificity, and action. Any two of those three present, charges become viable. And yet, even then, the First Amendment throws sand in the gears, because political speech is the most protected category in American law. Period. Courts have overturned threat convictions involving elected officials dozens of times in the last decade alone. The Supreme Court keeps moving the goalposts higher. The founders designed it that way deliberately. They had just lived under a king. Criticizing, even threatening, the head of state was the first freedom they wanted to protect. There's a dark irony here. The law designed to protect the president may actually make him more vulnerable, because it forces the Secret Service to manage threats rather than eliminate them. If you found this useful, hitting that subscribe button helps us keep making deep dives like this one. We put out new episodes every week. So what would actually fix this? Some legal scholars argue for a pure objective standard. Forget intent, just ask if the words were threatening in context. But others warn that removes the First Amendment safeguard entirely. A president could then silence critics by simply saying their words felt threatening. The tension is not a bug. It's the feature. American law deliberately chose a harder prosecution standard to keep political speech free. The cost of that freedom is that threatening words mostly go unpunished. The benefit is that no administration can prosecute its way to silence. The next time you see a news headline about someone being investigated for threatening the president, remember this. Investigation doesn't mean charges are coming. And charges don't mean conviction. The law has 3 separate walls between a threat and a prison cell. The 1917 law still stands. The subjective intent standard still reigns. And tens of thousands of new threat files will open again this year, with almost none of them going to trial. That's not failure. That's the American legal system working exactly as designed. Whether you think that's a triumph or a flaw depends entirely on who's in the White House. If this changed how you think about the First Amendment, drop a like. It genuinely helps this kind of content reach more people who'd find it valuable. Next week, we're covering how the Secret Service decides who actually gets a protective detail, and why some of the most threatened people in America get nothing. You won't want to miss it.